let's get back to technology again briefly. You all are involved in a drug conspiracy and have used a computer to do so. And I'm law enforcement, and I've gotten probable cause now to come and look at your computer in order to retrieve financial records showing the conspiracy. And while I'm looking for those financial records, I happen to find lots of child pornography. Can that be used to prosecute me? How and why? Or why not?
Well, I would say you could do that because plain view is a warrant exception.
How's it plain view?
Well, if you take, for example, if you're going in to go search a kitchen, and on the counter in the dining room, you see something that could be also it could be used against them, then you're allowed to take that. I think you could apply that to the computer, where if you're going in to search something and something in plain view is also there, then that could be incorporated as well.
I disagree with Lauren. I think that when you get a warrant, you have to specifically say what you're going to search for and what you want to find. And since you were searching for the drugs, not child pornography, I don't think you should be able to prosecute someone for something that you weren't intending to search for.
Let's assume hypothetically, and believe me, I am no techie, that the child pornography that's in that computer is contained within a number of individual files that essentially have to be unlocked in order to access the information in them. Do you see any analogy between that kind of computer file and a closed container?
Yes, I do. As I stated in Cat's views before, as long as you follow the guidelines and the rules when you're staying in a hotel or close the phone booth behind you, you have this reasonable expectation of privacy. So when you have the password there or something that has to be unlocked, that is saying I don't want people in looking at this, and all of a sudden you have a reasonable expectation of privacy.
All right, so if there is an analogy to closed container, what is the significance of the fact that the computer file is like a closed container for Fourth Amendment purposes?
Well, I mean, I would relate this to, say, a government official or a government agent is searching your house looking for, say, a marijuana grow, which is suspected to be in a cabinet up on, like, top right of your bureau or something like that. Okay.
Go ahead, finish your thought. Go ahead.
Say there were a safe right by this, then you would not check the safe because you already have a particularity requirement to search that shelf. So there would be no reason for you to search that area. So therefore, the warrant would be unconstitutional if you check that.
Okay. All right. Thank you very much. Job well done. Judd, a few comments?
Sure. You all clearly have the most difficult unit out there, and I'm sure you all understand that, and I'm sure your colleagues understand that as well. No. It is a tough question, though, and you all did a very, very good job of dealing with it. The issue of the reasonableness of privacy and the reasonable expectation of privacy has been a moving target for a long, long time. It continues to move just because, but also moves because of technology, and you all talked about that quite a bit and did a very nice job of talking about the historical underpinnings as well as the current disputes and issues that are surrounding and underlying it. So in that respect, I think it's the job you all did was extraordinarily good in terms of hitting those particular issues. I just wish we had a little more time to talk a little bit further, because at the end of the day, your views are going to be far more important on this issue than mine, because you all are going to be the ones who are going to be in charge when I'm a little on the older side. So I'll just say, keep on thinking about privacy, my personal privacy, and we'll go from there. Thank you all very much.
Judge?
I also thought you did a terrific job. Your 4 minutes of testimony gave a good overview. I had to test my own imaginative capacity in devising questions to ask you, because the position that you took with respect to the relationship between the Fourth Amendment and ever increasingly sophisticated technology was such a reasonable position. I think you did a good job of fielding the questions that we asked. The open or the closed container question was something of an inspiration on my part. The law of closed container is not something that I would have expected you to have studied, and I don't think you did. And so I don't think you quite got what I was fishing for with respect to what the significance of a computer file would be if it were like a closed container in terms of the prerogative of the government or a law enforcement official to open the file without seeking a warrant. But barring that, I thought you did a terrific job, and I commend you. Thank you.
You know, guys, I'm a trial judge, so I have lawyers in my courtroom arguing these issues every week. And, you know, if they'd show up here, most of them, if they'd show up here, they'd learn something. True. And, you know, this is, I think I said, I hope to the other team that, or the other part of your team that I judge, you know, it's just an absolute pleasure to enter into a dialogue and watch you all think on your feet. And you're not trained at this. I see lawyers that don't do as well as you do, and they're trained in this. This issue is going to affect you. You people are going to have to decide all about these iPhones and all about these computers and MySpace and Facebook, and you put it out there, and does all that mean that it's for governmental use? You are the ones that are going to have to decide where your privacy starts and ends, and you started that process by studying this question, and so I feel confident that you'll figure it out. Awesome job. You should be very, very proud of yourself. Congratulations.